Every legal encounter leaves a trace. Every strict investigation pursues honesty. Comprehending your legal rights, establishing true justice.
Your badge number and the name of your supervisor.
You need to step back, sir.
I am entitled to that information. Badge number, now.
Gate H, non-compliant passenger.
I am not non-compliant. I have done nothing wrong.
There are verdicts that close cases, and then there are verdicts that close departments. What happened inside Chicago Union Station on a Thursday morning in January did not begin as a confrontation. It began as a commute, a federal judge, a priority boarding corridor, a 13-minute interaction that ended with that judge face down on a marble floor, in handcuffs, bleeding from a gash above his eye, while the most consequential hearing of his judicial career began in Washington without him. The officer responsible filed a damage report on his body camera that same afternoon. The camera had been recording the entire time. If you are new here, subscribe and drop your location in the comments. This channel covers stories that deserve more than a headline, and this one sits at the top of that list. Here is exactly what happened. Chicago Union Station does not slow down for January. 6:48 in the morning. The Great Hall was already running at full capacity, commuters in heavy coats moving fast across the marble floor, Amtrak staff cutting between platforms, business travelers navigating the concourse with the mechanical efficiency of people who have done this hundreds of times. Departure boards cycled through the morning schedule. The overhead announcements came in waves. The station breathed with the rhythm of a city that starts early and moves without waiting. Near Gate H, the priority boarding corridor was processing passengers in steady rotation. A man approached from the south end of the concourse. Early 60s, silver at his temples, close-cropped. Dark wool overcoat, leather document bag worn at the shoulder, the deliberate, unhurried walk of someone with authority so long established it no longer needed to announce itself. His federal judicial identification and Amtrak travel authorization were already out and visible, held forward in his left hand before he reached the gate, a habit built over 4 decades of moving through secure federal spaces. An officer near the corridor entrance had been watching him since he came through the main doors. The officer stepped into his path 6 feet before the gate and told him the priority corridor was for verified passengers. He said general boarding was at the far end of the hall. He said it at the volume of a man who wanted nearby commuters to hear the direction being given. The man stopped. He extended his credentials and identified himself as a federal judge on the 7th Circuit Court of Appeals, traveling on official judicial business to Washington. The officer took the identification. He held it for 3 seconds, not long enough to read the full text, not long enough to examine the federal court seal embossed across the lower half of the card, not long enough to match the photograph to the face of the man standing 2 feet in front of him. He handed it back and told him to step aside for additional screening. Behind him, a white man in a North Face jacket walked through the corridor without breaking stride. A white woman with a rolling bag was waved through with a nod. A white man in his 70s was assisted through the gate by a station employee who held his coat while he gathered his things. None of them were asked for anything. His name was Judge Leonard Cross. Born in Englewood, on the south side of Chicago, the youngest of 4 brothers raised by a postal worker and a public school vice principal. He was the first in his family to attend a 4-year university, the first to sit for the bar, and the first to be appointed to the federal bench in the Northern District of Illinois, an appointment that came after 23 years as a federal prosecutor, during which he had argued cases that other attorneys declined on the grounds of complexity or political risk. He graduated with honors from DePaul University College of Law, joined the U.S. Attorney's Office 11 days after passing the bar, and spent the next 2 decades prosecuting public corruption, organized crime, police misconduct, and civil rights violations across the Northern District. He had put aldermen in prison. He had dismantled narcotics networks with federal reach. He had stood before juries in this city and delivered evidence that sent law enforcement officers to federal correctional facilities. He had won those cases. When the president nominated him to the 7th Circuit, the Senate confirmed him 83-13. His written opinions on Fourth Amendment protections, equal protection jurisprudence, and the constitutional limits of law enforcement authority were assigned reading at the University of Chicago, Northwestern, and Vanderbilt law schools. Colleagues on the circuit described him as one of the most prepared appellate judges they had encountered in combined decades on the bench. That morning, he was traveling to Washington for something that had kept him working past midnight for 3 consecutive nights. The 7th Circuit was convening an emergency en banc session, all active judges A full panel to hear arguments in a case challenging the constitutionality of mandatory minimum sentencing enhancements applied disproportionately to black defendants across 3 federal districts. The case had been on the circuit's docket for 14 months. The en banc call had come down 6 days earlier. Oral arguments were scheduled for 10 o'clock. Judge Cross had written the order convening the session. His document bag contained his judicial identification, his federal travel authorization, a letter of diplomatic courtesies from the U.S. Marshal's Service, 41 pages of bench notes he had compiled over the preceding week, and a draft concurrence he had been refining since Sunday. He had made this trip from Chicago Union Station more than 50 times. He had never once been stopped at the gate. Officer Todd Brewer, 46, had been posted at Chicago Union Station with the Transit Authority Police for 14 years. In that time, his personnel file had accumulated 26 formal complaints from passengers. 22 of those complaints came from black or Latino travelers. The allegations were not varied. They described the same conduct in the same locations, applied to the same category of passenger year after year. Racial profiling at priority boarding areas, unlawful detention in first-class waiting lounges, verbal intimidation, physical force used against individuals who were not resisting and had not been given any lawful reason to expect it. Not one complaint had been assigned to a disciplinary panel. Not one had produced a suspension, a retraining requirement, or a formal reprimand. His direct supervisor, Lieutenant Dale Croft, 53, had processed every dismissal through the same administrative language. Insufficient basis for formal review, no corroborating independent account, conflicting passenger statements. Brewer had received 2 commendations, one for service excellence, one for proactive passenger management in high-volume transit periods. Among colleagues, he was known for where he positioned himself. He chose the priority corridor in the first-class waiting area because, as he had said to fellow officers on multiple documented occasions, those spaces attracted passengers who needed reminding that access was conditional. A black federal appellate public defender had been detained in the priority lounge for 110 minutes in 2021 while traveling to a circuit argument. A black Cook County Circuit Court judge had been redirected from priority boarding on 5 separate occasions across 3 years and had filed 5 complaints, none of which had been given a case number. A black retired DEA special agent in charge had been told at Gate H that his federal retiree identification required additional verification from a supervisor before it could be accepted. Every complaint dismissed within the week it was filed. By the time Todd Brewer stepped into Leonard Cross's path on that Thursday morning in January, he had been executing this pattern for 14 years without a single sustained consequence reaching him. Judge Cross was not a security situation that had materialized. He was a selection Brewer had made before the judge had covered the last 50 feet of concourse between them. Brewer called for backup and logged the judge as a non-compliant passenger obstructing a priority boarding area. Judge Cross had not raised his voice. He had not stepped forward, stepped back, or moved in any direction without being directed to do so. He had not made any physical gesture that a reasonable observer could characterize as threatening or aggressive. He had asked, with the precision of a man who had spent 23 years in federal courtrooms, for Brewer's badge number and the name of his on-duty commanding officer, information that any member of the traveling public was legally entitled to request from a transit officer on duty. Brewer grabbed him by the front of his overcoat, both hands, a grip on the lapels that pulled him forward and sideways simultaneously, spinning him off his center of balance. His document bag swung off his shoulder and hit the marble floor with force that buckled the brass clasp. 41 pages of bench notes, the en banc session schedule, the Marshal's Service letter, the draft concurrence he had been writing since Sunday, spread across the concourse in a wide arc. Commuters nearby stopped. Phones came up from pockets and bags. A station employee near the Gate H newsstand took several steps toward the scene and then stopped, uncertain. Brewer drove him toward the low steel barrier beside the gate entrance. Judge Cross's shoulder struck the metal edge with force that would later be documented in medical records as a partial separation of the acromioclavicular joint. He cried out. His reading glasses left his face and skidded 8 feet across the marble. Brewer forced both arms behind his back, dropped his knee into the back of the judge's left leg, and drove him to the concourse floor, face forward, onto the marble surface, in the Great Hall of Chicago, Union Station, in full view of the morning commuter crowd. He had not resisted. He had not raised a hand toward Brewer at any point. He had not given a single justification for a single second of what was being done to him. Brewer placed his knee on the back of the judge's neck and reached for his handcuffs. He said clearly, at full volume, with 6 security cameras and at least 40 commuters within direct sightline, that people like him always wanted to turn a simple direction into a federal case. Judge Cross's cheek was against the marble. His glasses were somewhere behind him in pieces. His shoulder was producing pain that he would later describe to medical staff as immediate and severe. His voice, when he spoke, was level. He told Brewer he was a federal judge on the 7th Circuit Court of Appeals, that what was happening constituted assault under color of law, that it was being recorded from multiple positions, and that Brewer should consider carefully whether he wanted to continue. Brewer told him he could keep talking. He locked the handcuffs. 6 security cameras captured the entire sequence without interruption. Not one of them malfunctioned. Not one of them missed a frame. What Todd Brewer did not know, sitting in the break room an hour later, filing his incident report, confident that the standard process would handle, what the standard process had always handled, was that his own body camera had been running without interruption since 6:38 that morning. The first call reached Transit Authority Police Chief Raymond Gould at 7:02. The second arrived before he had finished reading the first message. The third came from the office of a Chicago alderman whose constituent had filmed the full sequence from the eastern side of the concourse and posted it before Brewer had finished writing his report. Gould was 60 years old, 24 years in transit law enforcement, the institutional architecture of a man who had built his career on the premise that problems processed quickly became problems that disappeared. He arrived at Gate H 9 minutes after the handcuffs went on, moving at the pace of someone who had already calculated that the variables in front of him were not cooperating with that premise. He pulled Concourse Floor Supervisor Janet Reese aside at the gate entrance and asked her one question. She told him the name of the man on the floor. The 2 seconds that followed produced an expression on Gould's face that 2 separate security cameras captured from different angles and that prosecutors would later describe to a jury in precise detail. It was not alarm. It was not concern. It was the specific calculation of a man who had just identified a problem that was already larger than his ability to contain it and was running the available options in real time. He crossed to Brewer and told him in a low voice to remove the handcuffs. Brewer pushed back non-compliant subject, physical threat assessment, witnesses available to corroborate. Gould said the subject's name, his court, and his Senate confirmation number without raising his voice. The handcuffs came off. When Judge Cross was helped to his feet, left arm hanging at a reduced angle from the shoulder separation, a cut above his right eye from where his face had contacted the marble edge of the barrier during the takedown, his overcoat torn at the left shoulder seam, Gould moved close and reduced his voice to something that the cameras would strain to pick up. He mentioned the station's administrative suite on the upper level. He mentioned the department's medical liaison. He began outlining a process by which the incident could be reviewed through internal channels before any formal external reporting obligation was triggered. Judge Cross looked at him for a moment. He had spent 23 years building federal cases against men who opened with that exact sequence. He told Gould that he recognized the structure of what was being attempted. He told him he had obtained convictions using it as exhibit material. He looked at the camera mounted to the column directly above the gate. He looked back at Gould. He told him the external reporting process had already been triggered by 6 cameras, by 40 witnesses, and by the phone of a retired federal attorney who had placed a 911 call while Brewer's knee was still on his neck. Then he told Gould he needed to make 2 calls, and that neither of them was to the department's legal counsel. The woman who had pushed through the morning crowd while Brewer was still applying his weight to the judge's neck was 60 years old, wore a gray wool coat, and moved with the purposeful speed of someone who had spent decades in federal buildings where emergencies required immediate professional responses. Her name was Beverly Strand, 33 years as an assistant U.S. attorney in the Northern District of Illinois, retired 2 years earlier. She had argued motions before Judge Cross on the district bench on 6 separate occasions before his circuit elevation. She had recognized him from across the Great Hall the moment Brewer's hands closed on his lapels. She identified herself by full name and professional title, raised her phone, and placed a 911 call while the assault was still in progress, using the language of someone who understood exactly which words would trigger which federal responses. Assault under color of law. Federal appellate judge, Chicago Union Station Main Concourse Gate H, partial separation injury, federal notification required. She gave the gate number twice. When Chief Gould turned to the commuters clustered near the barrier with their phones raised and told them the transit authority would need to collect those devices as part of the department's evidentiary process, Strand told him without changing her tone that warrantless seizure of bystander recordings violated federal law and that she would personally file the motion to suppress any evidence obtained through that process before the week was out. Gould left the devices where they were. Judge Cross refused transport to the hospital. He sat on a bench near the gate, a transit authority medical officer stabilizing his left arm in a temporary sling, and made his 2 calls. The first was to the Chief Judge of the Seventh Circuit. He explained that he would not be present for the 10 o'clock en banc session. He explained why. He said the session should proceed without him. The Chief Judge told him it would not. The emergency en banc hearing on mandatory minimum sentencing disparities, the case Judge Cross had spent 3 nights preparing for, the session he had personally convened, the argument that 14 months of procedural history had led to that specific Thursday morning was postponed. The panel could not constitute a proper quorum without him. The rescheduled date would be set for 6 weeks later. The case that was supposed to be heard that morning involved sentencing guidelines that affected thousands of pending federal cases across 3 districts. 6 weeks of postponement had direct consequences for defendants currently awaiting outcomes that depended on the circuit's ruling. The second call was to the FBI's Chicago field office. The Chicago FBI field office logged the notification at 7:17. 3 special agents arrived at Union Station within 19 minutes. They secured the scene, cataloged every recording device in the immediate vicinity, and placed the Department of Justice Civil Rights Division on formal notice before 7:55. By 8:20, the footage was running on national news networks. By 9, it had been viewed more than 8 million times across social media platforms. By 10 o'clock, the hour at which Judge Cross should have been seated on a federal appellate bench in Washington, his face was on the front page of every major digital news outlet in the country. The FBI subpoenaed the station's full security archive before 10:30. 6 cameras, fully synchronized, complete coverage of every second from Brewer's initial positioning at 6:51 through the moment the handcuffs were removed. The Great Hall's acoustics, high ceilings, marble surfaces, open floor plan had carried the audio with a clarity that investigators described in their report as exceptional. Brewer's incident report, filed at 9:53 that morning, stated that the subject had been verbally combative, had refused repeated lawful directions, had adopted a physically aggressive posture that constituted a credible threat assessment, and had required restraint to prevent escalation to other passengers in the corridor. 6 cameras from 6 separate fixed positions with synchronized audio contradicted every element of that account. 6 cameras, a body camera, dozens of witnesses with phones already recording, a retired federal attorney on a live 911 call while the assault was still happening. Before any of that existed, before cloud backup, before the footage was already uploading to national news servers, before the handcuffs came off. Do you think a word of what actually happened in that concourse would have survived the week? Drop yes or no in the comments. And if this story deserves a wider audience, share it. Most people still do not know that the hearing he missed that morning was about the exact kind of institutional bias that put him on that floor. Brewer had submitted his body camera damage report at 10:14 the same morning. He stated that the device had sustained physical impact damage during a crowd management response on the prior shift and had been non-operational since 6:51, 2 minutes before his initial approach of Judge Cross. The report cited a specific hardware fault code. It had been reviewed and countersigned by Lieutenant Dale Croft before noon. FBI forensic technicians accessed the Transit Authority's cloud backup infrastructure 37 hours after the assault. The camera had not sustained damage. It had been recording continuously and without interruption from 6:38 that morning. The footage showed Brewer at the priority corridor entrance at 6:51, positioned with a direct sightline to the main concourse entry. He spotted Judge Cross approaching from the south doors, a man in a dark overcoat moving at a steady pace, credentials already visible in his left hand, document bag at his shoulder. Brewer watched him cover approximately 60 feet of concourse. He then turned to the officer beside him, Officer Dennis Holt, 34, and said, with an expression that the forensic video analyst would later describe in court testimony as anticipatory, that he had a live one coming and that this one was going to think his credentials meant something. He told Holt to watch how it went. He had not reacted to a security situation. He had observed a black man entering his territory, made a decision about how the next several minutes would proceed, and moved to the gate entrance to execute it before Judge Cross had reached the halfway point of the concourse. The hardware fault code cited in the damage report, forensic technicians testified under oath, did not correspond to any fault in the device's operational log. The log showed continuous function. The fault code had been entered manually into the reporting system after the device had already been submitted. The countersignature from Lieutenant Croft meant that Croft had either reviewed and approved a falsified technical report or had signed it without reading it. Investigators determined within 72 hours that it was the former. The damage report was not a misunderstanding of technical terminology. It was a document fabricated with a specific operational purpose to eliminate the recording that showed Brewer selecting his target before the target had done anything at all. Every complaint that had ever been filed against Todd Brewer, every detained public defender, every redirected circuit judge, every dismissed allegation across 14 years was no longer a disconnected series of passenger grievances that had failed the evidentiary threshold for disciplinary review. It was a documented record of premeditated, repeated, institutionally protected conduct carried out by a man who had every reason to believe the system above him would continue to absorb the paperwork. The Department of Justice Civil Rights Division opened a formal investigation into the Chicago Union Station Transit Authority Police 9 days after the assault. What they recovered went substantially beyond one officer and one gate. Internal communications pulled from department servers revealed a coordinated scheme that 7 officers, Brewer among them, had maintained and referred to in a shared text message group as the Standard. The operational objective was direct: identify Black and Latino travelers in priority boarding corridors and first-class waiting areas, and redirect them to general boarding through whatever level of intervention the situation required. The officer with the highest weekly redirect count received a cash payment from the group at the end of each week. Lieutenant Dale Croft had not been a passive administrator processing paperwork for officers he supervised. He had structured the scheme. Recovered messages showed him setting weekly redirect targets, tracking individual performance against those targets, and in one message recovered from a deleted thread that FBI technicians reconstructed from server fragments, writing that Brewer had posted numbers for the quarter that nobody in the unit was going to touch. He had been running a performance management system for racial profiling with the organizational discipline of someone who had never been given any reason to expect external scrutiny. The 26 prior complaints against Brewer were re-examined by investigators who did what the department's internal affairs process had never done. They contacted the complainants directly. 21 responded to outreach, 18 agreed to provide formal statements for the federal investigation. A Black federal magistrate judge, who had been physically removed from the first-class waiting area and held in a secondary screening room for 90 minutes in 2020. A Black Illinois appellate court justice who had been redirected from priority boarding on 6 separate occasions across 4 years, who had filed 6 complaints with the Transit Authority, and none of whose complaints had ever been assigned a tracking number. A Black retired FBI supervisory special agent who had been told at Gate H that his federal law enforcement retiree credentials required verification from a Transit Authority supervisor before they could be accepted as valid for priority. Boarding access a verification requirement that existed nowhere in the Transit Authority's published passenger policy. Over 12 years, 891 complaints had been filed against Chicago Union Station Transit Authority police officers. 87% involved Black or Latino passengers. Not one had resulted in a sustained finding against any officer. Not one complaint in 12 years across nearly 900 filings had produced a single disciplinary outcome. The only explanation consistent with that statistical record was that the process for reviewing complaints had been designed to produce that outcome. The federal grand jury convened 7 weeks after the assault. The indictments were unsealed on a Monday morning, and they landed on every level of the command structure that the DOJ investigation had mapped. Todd Brewer was charged with assault under color of law pursuant to 18 United States Code Section 242, conspiracy to deprive civil rights, filing false federal reports, obstruction of justice, and evidence fabrication for the falsified body camera damage report. The evidence fabrication charge carried exposure that his attorney described in a conversation later recovered during discovery as the charge that changes everything about how this case resolves. Lieutenant Dale Croft was indicted as co-conspirator, conspiracy to deprive civil rights, obstruction of justice, failure to prevent a federal civil rights violation, accessory after the fact for countersigning a damage report he knew to contain fabricated data. He had not simply processed dismissals. He had built and administered the scheme that made the dismissals necessary. Chief Raymond Gould was indicted separately for obstruction of justice and attempted witness intimidation. Every action he had taken at the scene, the administrative suite offer, the attempt to collect bystander devices, the instruction to Janet Reese not to make statements to arriving federal agents until she had spoken with department counsel, the approach to Beverly Strand that Strand had documented in a written account submitted to the FBI within 2 hours of the incident had been captured on camera. His attorney's argument that the conduct reflected reasonable crisis management did not survive contact with the footage. Officer Dennis Holt accepted immunity in exchange for full cooperation. He sat before investigators over 3 separate sessions and described the standard scheme from its origins, the text message group, the weekly target setting, the cash transfers, the understood protection that ran from the officers on the floor through Croft's office to the chief's awareness, and the shared departmental understanding that any complaint filed by a minority passenger would not produce a consequence before the end of the week in which it was filed. 3 additional officers from the standard scheme were indicted on civil rights conspiracy charges. The federal trial of Todd Brewer ran for 4 weeks. It drew a consistent gallery, civil rights litigators, constitutional scholars, federal judges from districts across the 7th Circuit, journalists from every major national outlet, and 18 of the prior complainants who had provided statements during the investigation. On the morning closing arguments were delivered, the Cook County courtroom had a waiting line that formed before 5 in the morning. The defense theory was threat assessment and training compliance. Brewer's attorney argued that the body camera footage lacked the contextual framing necessary to establish intent, that the standard text messages reflected the kind of informal professional shorthand common in high-pressure transit environments, and that the 26 prior complaints demonstrated not a pattern of misconduct, but a pattern of passenger retaliation against an officer who enforced policy consistently. The prosecution played the body camera footage on the courtroom screen. No narration, no annotation, no preliminary remarks. The Great Hall concourse entrance, Brewer at the gate, positioned and waiting, his eyes tracking the south concourse entry. The moment Judge Cross comes through the main doors 60 feet away, moving at a steady pace, identification already visible, Brewer watching him cover the distance, the turn to Holt, the expression, the words. The courtroom produced no sound for 11 seconds after the footage paused. Brewer took the stand in his own defense over his attorney's documented objection. He testified that he had no clear recollection of the specific exchange with Holt. He said the footage had been extracted from a longer operational context that would have framed his assessment differently. He said the 26 complaints against him reflected a coordinated campaign by passengers who had been subjected to lawful enforcement action and chosen to process their objection through the complaint system rather than comply at the point of contact. The prosecution presented the standard text messages in sequence. The weekly redirect tallies maintained across 18 months. The mobile payment transfer records. The messages from Croft. The forensic testimony establishing that the hardware fault code in the damage report did not exist in the device's operational log, and that the log entries showing continuous operation had not been tampered with, meaning the only document in the record that claimed the camera was non-functional was the report Brewer had filed. He had not responded badly to a situation that escalated beyond his management capacity. He had watched a man walk toward him from 60 feet away, decided what was going to happen in the next several minutes, positioned himself to execute it, and spent the rest of that Thursday constructing a paper record to eliminate the evidence that documented the decision. The jury deliberated for 8 hours across 2 days. Unanimous on every count. Brewer was sentenced to 11 years in federal prison and received a permanent lifetime prohibition from law enforcement employment in any capacity in any jurisdiction in the United States. Croft received 6.5 years, Gould received 4 years, and surrendered his full pension and all accrued departmental benefits. The 3 additional officers from the standard scheme received sentences between 22 months and 3 years and 10 months. The twist that the city's attorneys had not fully accounted for when they moved to open settlement discussions 5 months after the sentencing was this. Judge Cross had spent the morning of the assault preparing for a hearing about systemic racial bias in federal sentencing. The session had been postponed because he was face down on a concourse floor. The postponement had delayed outcomes for defendants in pending cases across 3 federal districts. And the lawyer now sitting across the settlement table from the city's legal team was a man who had written the opinion language on deliberate institutional indifference that the city's own expert witnesses were about to be cross-examined against. The city offered $9 million. They attached a confidentiality clause. Judge Cross declined. His response was a list of conditions with no dollar figure attached. A formal signed public admission of wrongdoing, not a statement of institutional regret or a commitment to improvement, a legal admission. Complete dissolution and reconstruction of the Transit Authority police force with an externally managed hiring process. An independent civilian oversight board with investigative authority, subpoena power, and a charter provision explicitly prohibiting any form of departmental review or interference in active investigations. Mandatory civil rights and bias training certified by an external body for every officer in the reconstruction. A federal consent decree establishing a minimum of 10 years of Department of Justice monitoring with public quarterly reporting. The city rejected the conditions and proceeded to trial. 3 weeks of testimony. Statistical analysis of 891 complaints filed over 12 years, 87% involving Black or Latino passengers. 0 sustained findings in the entire period. Expert testimony that the probability of producing that outcome without active institutional suppression of the complaint review process was, within any standard model applied to the data, effectively 0. The jury deliberated for 3 days. $23,600,000. $13,900,000 in compensatory damages. $9,700,000 in punitive damages against the individually named officers and supervisors. The largest civil rights verdict rendered against a transit authority police department in United States history. The city announced an appeal within 30 days. The appeal was never filed. The full amount was transferred within 52 days of the verdict. The Chicago Union Station Transit Authority Police Department was disbanded. The reconstruction brought externally recruited leadership, revised hiring criteria that included civil rights, compliance history as a screening factor, mandatory body camera protocols with tamper-evident cloud archiving that department personnel could not access or modify, and a formal policy requiring independent external review of every complaint involving force or alleged discriminatory conduct before any internal disposition could be entered. The Civilian Oversight Board was constituted with full investigative authority, subpoena power, and a charter that explicitly and specifically prohibited departmental interference at any stage of any active review. A federal consent decree locked in 10 years of Department of Justice monitoring with mandatory quarterly public reporting. 21 additional complainants filed civil suits in the 8 months that followed. Their combined settlements reached $14,100,000. The en banc hearing on mandatory minimum sentencing disparities was rescheduled and heard 6 weeks after the assault. Judge Cross was present. The panel issued its ruling 11 weeks later. The opinion, which held that sentencing enhancement patterns across the 3 districts under review reflected a constitutional violation of equal protection guarantees, was authored in part by Judge Cross. It was cited in 47 subsequent federal cases within the first year of its publication. 2.5 years into his sentence at a federal correctional facility in Terre Haute, Indiana, Todd Brewer gave a recorded interview to a journalist writing about long-term outcomes in high-profile civil rights prosecutions. He said he had done what his position required him to do. He said the subject had escalated what should have been a brief interaction. He said the outcome would have been different if the man had simply followed the direction he had been given at the gate. Judge Leonard Cross, who had by then returned to full active status on the Seventh Circuit, who had authored 3 published opinions in the intervening period, and who had established the Cross Foundation for Civil Rights Litigation, a nonprofit providing legal representation to individuals who had experienced discriminatory conduct at the hands of law enforcement and could not afford private counsel, was asked to respond. He said he had followed every direction, from the first word spoken to the last word before Brewer's hands closed on his coat, credentials presented before being asked, hands visible, voice control, complete compliance at every point while being assaulted on the marble floor of a public train station in the city where he was born, during the morning commute of a day on which he was scheduled to hear arguments about the precise institutional forces that had just put him face down on that floor. He paused for a moment before continuing. He said the cooperation argument was not really about his behavior. It had never been about his behavior. The argument Brewer had been making for 14 years, the one he made every time he stepped into the path of a black traveler in that corridor, was that presence in a priority space required a justification from certain people that it did not require from others. That credentials, accomplishments, and decades of federal service did not change the calculation he had already completed before the man had crossed half the distance of the concourse. He said the cameras documented what the department had spent 14 years ensuring no one would ever be able to document. He said the only thing the verdict could not address was the belief that made the conduct feel reasonable to the man who carried it out, and that resolving that belief was work that no single case, however large its verdict, could finish on its own. 10 months after the assault, Judge Leonard Cross walked through Chicago Union Station for the first time since January. His shoulder had completed its rehabilitation. The cut above his eye had closed without a scar. He wore the same dark wool overcoat, replaced at the left shoulder seam, where the fabric had torn on the gate barrier. He carried the same leather document bag. He walked at the same pace, the measured, unhurried stride of someone who had spent 4 decades moving through institutional spaces and had decided, somewhere in the months of recovery and litigation and writing and foundation building that followed, that he was not going to move through them any differently. His federal judicial identification was visible in his left hand as he crossed the Great Hall, not because the new officers would ask for it, because he had decided it would be visible, not as a precaution, not as a concession to anything, as a statement about what had happened in this building and what had changed because of it. The new transit officers at Gate H nodded as he approached. A young black man in a new uniform, part of the first cohort hired through the externally managed reconstruction process, recognized him and stepped forward. He said he had followed the case. He said he worked there now because of what Judge Cross had refused to let go quietly. He said 2 words. Judge Cross looked at him for a moment. Then he nodded once. He walked through the priority corridor without being stopped.
If you like this video, make sure to hit that like button, subscribe, and turn on the notification bell so you don't miss the next story. Share this video with someone who would appreciate it, and let's keep building this community together. And before you go, drop a comment below. I'd love to hear your thoughts on what stood out to you the most. Until next time, stay safe, stay curious, and I'll see you in the next.
Truth is a continuous pursuit, and awareness is your best defense. Thank you for watching and championing global transparency.